Hello, this is Brian Rowe for New NIIP, Episode 2, Omega v. Costco and the First Sale Doctrine. So before we really get into why this case is extremely important, let me give you a little bit of background. Omega is an extremely famous watchmaker, Swiss watchmaker whose watches were worn by JFK and Buzz Aldrin on his famous flight to the moon. And Omega really wants to control the price of their watches. This is an Omega watch. Omega watches run for about $2,000 on up to about $7,000 here in the US. And Costco is a wholesaler who's really dedicated to providing the lowest price possible to consumers. Costco saw that Omega was selling watches in the EU for significantly less than the price that they were offered here in the US. So Costco sent a buyer over to the EU to buy a bunch of watches, bring them back to the US, import them legally, and sell them to customers here in the US. All of the sales in this transaction are legal. There was nothing wrong with this. It's called gray market importing, where you buy in one market for one price and then move it to another market where it may be priced differently. Omega really didn't like this because it cut into some of their profit margin. And what Omega did is looked at copyright, which has some distribution rights around it, and tried to come up with a really creative way to prevent distribution in the US using copyright law. So what they did is they took the watch that they had and they put a very little emblem on the back here. Now I'm going to move this up really close to the camera. There's a little purple dot there. It's about a half a centimeter across in size. And what they did is where that dot is, they put a half centimeter picture of a globe on each of their watches, and they registered this with the US Copyright Office. And then when Costco bought a bunch of watches, they used this copyrighted image sitting on the back of the watch as a distribution rights holder, so that the importing of these watches triggered a copyright suit. Now, this is ridiculous for two reasons. Number one, I don't know about you, but I don't buy a watch for this little tiny symbol sitting on the back. In fact, I spent about an hour at a jeweler's yesterday looking for different watches with this symbol. The individuals helping me out didn't even know that the symbol was there. The symbol has been there for 3 years. We had to pull out a little jeweler's magnifying glass to look at it and see what it was. Nobody buys the watch for this. This is not the intent of copyright. It's not a creative work that we're supposed to be protecting the distribution of. It's really just a trap put on the back of the watches. The second thing that's really annoying about this is that they're really taking copyright and attaching it to this really functional physical piece of property and then trying to get a weird interpretation out of the statute. So let's move into some of the copyright issues here. In copyright, there's a concept called the first sale doctrine. And what the first sale doctrine says is, in the US, if I buy a book or any other copyrighted work, when I lawfully buy that, the distribution rights of the copyright holder are removed. You are allowed to resell it. So this is why we have huge resale stores for CDs. This is why we have secondhand bookstores. The transactional cost of going back to a rights holder and having to pay someone or get permission every time you wanted to redistribute that book seems kind of ridiculous. There are some countries out there that do have systems like that put in place. The US has a robust secondary market for copyrighted items because we don't. And more importantly, this idea of a first sale doctrine really comes from property law. And I would like to take a moment just to point out a wonderful amicus brief done by Jeff Pearlman over at Public Knowledge. He's an up-and-coming First Amendment lawyer there, and full credit on this brief really goes to him and the partnership with Electronic Frontier Foundation. But I want to point out one sentence that's in there, and this is probably the only sentence that I helped contribute to that brief while I was at Public Knowledge. But it looks at the history of the first sale doctrine, and it says the first sale doctrine is a statutory rule, but it finds its origin in common law aversion to limiting the alienation of personal property. Now, what that basically means is that this is a traditional property thing that has been put into intellectual property as a balancing factor. This is extremely important because there's two ways out there to really fix problems with intellectual property law. Number one, we can move forward and come up with a new system of laws that looks at the non-rivalrous nature of intellectual property, or we can take some of the provisions that have been around in property law forever and use those as balancing factors. The first sale doctrine is one of those balancing factors. The public knowledge brief does a great job of pointing out how having this first sale doctrine really balances the right holders of the person who owns the physical item with those copyright holders. Now, the reason this is such an important Supreme Court case is that the Ninth Circuit really interpreted the statute in a very odd way. The copyright statute, when it comes to first sale, says that this first sale right applies to anything that's lawfully made under this title. Traditionally, that means anything that someone has produced with copyright with the authorization of the owner and made a legal sale on. The Ninth Circuit, through some type of amazing mental gymnastics, has redefined this as meaning to be made in the United States. This could have horrible, horrible side effects on copyrighted works entirely. A lot of what we buy that's copyrighted is already made outside of the United States. Additionally, when we look at a digital economy, where are those digital items being made? It would be very easy to argue that all of those digital items are made outside of the United States, and therefore we wouldn't have this fundamental property right that has been put in the Copyright Act to protect you and I, the end user. Now, it's a little bit odd that the Supreme Court took this case on review. The Ninth Circuit is the only court that has really looked at this question, and the Supreme Court asked the Solicitor General, who's kind of the head legal advisor for the U.S., to look at this case and make a recommendation. And the Solicitor General said, no, you shouldn't take this case because, well, none of the other circuits have ruled on it. We only have one consistent ruling here, and the previous case law from the United States, they tried to argue was consistent with this ruling. Now, my guess is that the Supreme Court does not agree with the Solicitor General here that the previous case law, which really reinforces the first sale doctrine, is consistent, and hopefully they see how dangerous this precedent from the Ninth Circuit is. So I will continue to do updates on this issue over time, but this is going to be an extremely important Supreme Court case. We should see oral arguments probably in October and maybe a ruling end of the year or early next year. Thank you so much, and I would also like to thank Ben Bridges Jewelers, who helped me out by showing me some of the Omega watches, which I can't possibly afford on my current income, and the countless pawn shops which were able to find me a prop that would work for this video. Thank you, and until next week, this is New NIIP.